Good evening to the participants of the AIBE 2023 Cohort 17 and whose screening test will be going to be held on 5th February 2023 if it is not postponed. Anyone can unmute and read what I posted on the screen? Hurry up.
Welcome to the aspirants of
AIBE 2023 for today virtual class Constitution of India. Multiple choice questions.
Yes,
Multiple choice questions.
Okay. Multiple choice questions and starting today. Yes. Okay. The rest of the things is quite means as usual. So without wasting the time, let me go to our shooting. Yes. Be ready. And this is R&A bar examination, cohort 17 2023, Constitution of India multiple choice questions. Yes, you can see here also, which I highlighted last, 2021, my video also there in the YouTube. Just you can type it and you can get the video also. If you want, you can take the screenshot and the same wordings, you can type it and you can enjoy my earlier video also. And you could see that I have not repeated as far as possible. Okay, first question. How many articles and how many parts and how many schedules are there now in Constitution of India? Of course, it's a general question, but what I want to make it out, I want to show something more. Yes, options which are given here is 398, 25, 12. Option B, 448, 25, 9. Option C, 448, 22, 12. D, 448, 25, 12. Which is
option C correct, sir. 448, 22, 12.
Are you sure?
Yes, sir.
Yes. So now the question is, supplementary question is, how many times chapters appeared in the Vivek? Mute. Vivek, I'm getting the sound from you. Those who want to speak at the time, you can unmute. And when you don't want to speak, you can mute it. Otherwise, I will get the sound from you. Is it clear? Okay, now,
Yes, sir.
the purpose of supplementary question is, how many chapters? Do you think the chapters are there in the Constitution of India? Number one. If the chapters are there, how many times chapters are repeated? A, 87, B, 88, C, 89, D, 90. Shoot.
89 is correct, sir.
89 is correct. Okay, I appreciate it. Can you tell me in which part the chapter first appeared?
89 is correct, sir.
I repeat the question. In which part?
89 is correct.
You hear me the question, that is over. Answer is over. Nandini, mute. Nandini, K. Nandini, mute. I said, Nandini, mute. I am getting the sound from you. Okay. When you speak, at the time you can unmute it. Okay, now comes, in which part of the Constitution chapter 1 appeared first? That is my question. Anyone? Here I have given feedback. Part 5, the Union, heading chapter 1, the Executive. And there it is appeared. Of course, in many places it appeared, but 89 times it is appeared in the Constitution of India. Is it clear? Say yes.
Yes, sir. Yes, sir.
Okay. Second question. The preamble of the Indian Constitution has dash words. A, 71, B, 72, C, 73, D, 74. I say words.
72, sir.
73, sir. 73, sir.
The right answer is 73 is the right answer. 73 words are there in the preamble. Of course, I did not ask you, preamble is the part of the Constitution which case law said, preamble is not the part of the Constitution which case law said. These are all the old questions. Is it clear? Say yes. Sir, we don't know. Preamble is not the part of the constitution. It is a Berberai case. It is decided. But later on, in the Keshavananda Bharati case, preamble is the part of the constitution. Is it clear? At least say yes now. At least say yes now.
Yes, sir.
Okay, third question.
Yes, sir. Yes, sir.
Yes, I appreciate. Third question. How many important keywords in the preamble of Constitution of India? Option A, 7. Option B, 8. Option C, 9. Option D, 10. In the preamble, the keywords.
Audio is not clear, sir.
Yeah, no, it's visible. There is some problem with you only, but the recording is very quite good because I could see my palpitation here. When I speak, the palpitation comes over here.
No, sir. Voice is breaking, sir. Your voice is breaking.
See, the point is, signals are very good, no doubt at all. Signals are very good, no doubt at all. Okay, you can record, there is no problem at all.
Yes, sir.
In the record, there is no problem. Okay, how many keywords are there in the preamble? 7, 8, 9, 10.
Option A, 7, sir.
No, it's option 9 is the right answer. Option, totally there are 9, if I not be mistaken, yes. See, count it. Sovereign, socialist, secular, democratic, republic, justice, liberty, equality. How many are there total?
9.
Yes?
9.
9 is there. So 9 is the right answer for the question. Okay, fourth question. Anyone can unmute and read the fourth question?
Some of the
Key features of the Indian Constitution are listed below. Which one is the correct option? Option 1, federal system. Option 2, parliamentary from form of government. Option 3, integrated or independent judiciary. Option 4, fundamental rights.
And here I have given the options. A, 1
Option
plus
A,
2. Read.
Option A 1 plus 2, option B 1 plus 2 plus 3, option C 1 plus 2 plus 4, option D 1 plus 2 plus 3 plus 4.
Shoot.
D is right answer, sir. D is right answer. 1 plus 2 plus 3 plus 4.
WRONG.
What is 1, sir? Can you please move upside?
Federal system.
Federal system is not there. It should be 2.
C.
If I say C is the right answer, why the C is the right answer?
Integrated of independent.
Independent judiciary, sir.
It is independent judiciary, I know it. But why the 3 is wrong? You tell me the reason. See, integrated and independent judiciary. I removed the and I put the R. Is it clear?
Yes, sir. Yes, sir.
R means either this one or that one. And means both. Is it clear?
Yes, sir.
Yeah, I appreciate. The fifth question. The Indian Constitution guarantees dash fundamental rights. A, 5, B, 6, C, 7, D, 8.
B is right answer, sir. 6.
Which is the right answer?
B is right
B
answer.
is the right answer. Six fundamental rights are there. Okay, now the question comes. Sixth question. Which one is not a fundamental right? Number 1, right to equality and right to freedom. 2, right against exploitation. 3, right to freedom of religion. 4, natural and educational right. Now, options are given. A, 1 plus 2. B, 1 plus 2 plus 3. C, 2 plus 3 plus 4. D, 1 plus 2 plus 3 plus 4.
Options
B
B,
is
sir.
right
1
answer,
plus 2
sir.
plus 3.
Plus 2 plus 3 plus 4, sir.
Suppose if I say B is the right
It is
answer.
wrong, sir.
Can you tell me why the B is the right answer? What is wrong in the 4?
Yeah, natural and educational rights are
Sir,
not.
sir,
There is something I did it.
Cultural, sir.
Cultural, I appreciate. Venkat Reddy, I appreciate. There is a cultural
Education, right, sir.
and educational right. That is the, and here I removed the cultural and educational right, I made it. But there is also another right is also there, right to constitutional remedies. Is it clear?
Article 32.
Okay.
Yes, sir.
Now, seventh question. Anyone can unmute and read the seventh question. Those who read, give the chance to the other people.
Who wrote Indian Constitution? Prem Bechari Narayan Raizada was the head
Raizada.
of the Indian
Prem Bihari
Constitution,
Narayan
the original
Raizada.
Constitution.
Read.
The original Constitution was handwritten by him in a flowing italic style. A. Cartoonist. B. Calligraphist. C. Columnist. D. Calligrapher.
C is right answer, sir. C is right answer.
Read the total. As I read the total.
Prem Bihari Narayan Raizada was the dash of the Indian Constitution. The original Constitution was handwritten by him in flowing italic style.
As I read the total means answer, read the total. Who gave the answer? Don't say A, don't say B. Give the answer. A, cartoonist.
Sir,
Is it the right answer?
columnist is the right answer.
The right answer is D,
Columnist.
calligrapher. Calligraphер. The last one. And here highlighted. This is the right answer. Is it clear?
Okay, okay.
Okay, now next question. Vivek, mute. Venkat Reddy, mute. When you want to speak, at the time you speak. When I finish the D option. Eighth question. According to the architect of the Indian Constitution, Dr. B.R. Ambedkar, the right to constitutional remedies, which article dash is known as dash of the Constitution. Option A, Article 21, under the heart and soul. B, Article 32, the mind and soul. And C, Article 19, the brain and soul. Option D, Article 32, the heart and soul.
Option D, sir.
D.
Awesome.
D.
Article
Option D is the right answer. Article 32 and the heart and soul is the right answer. Article 32 you will find in the High Court.
No, sir.
Where do you find?
Sir.
District Court.
Supreme Court.
Supreme Court.
In the form of
PIL.
writ.
Writs, sir.
Rates. Yeah.
There are 5 writs.
Of course. Ninth question. The Supreme Court has a right to issue orders or writs in the nature of dash for the enforcement of the rights. Correct sequence you have to tell me. Here A, habeas corpus, prohibition, mandamus, certiorari and quo warranto. B, habeas corpus, mandamus, quo warranto, prohibition and certiorari. C, habeas corpus, mandamus, prohibition, certiorari and quo warrant. D, habeas corpus, mandamus, prohibition, quo warranto and certiorari.
B is right answer, sir.
Habeas corpus, mandamus,
mandamus,
C is right.
prohibition.
Yes, I appreciate it. Is the D is the right answer. I am not going to ask you what is habeas corpus, what is mandamus, what is prohibition, what is quo warranto, what is certiorari. This is the elementary questions. You should have to know it very long back. Feedback here is Article 32, Subarticle 2, the Supreme Court shall have the power to issue directions or orders or writs, including the writs in the nature of the habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any of the right conferred by this part. So, it is exact article is Article 32, Subarticle 2. Okay, 10th question. Anyone can unmute and read loudly.
Supreme Court cannot issue writs to
Cannot issue
A.
writs to
President or state governors. B. Chief Justice of High Courts. C. Chief Minister of State. D. Duties on voluntary interest.
D is right answer, sir. Duties on voluntary interest.
WRONG.
Option A, sir.
President and state government.
WRONG. If you say option A is the WRONG.
C is
Option
right
B
answer,
is
sir.
the
Option
Chief
B,
Justice
sir.
of
Right
Chief
answer,
Justice
the
of High
Chief
Court.
of the state.
The right answer is Chief Minister of the State.
Chief Minister.
Yes, sir.
You cannot file a writ against him. The reason I will tell you in one of the case law now. 11th question. Manumus writ command. Manumus is developed from the Latin word which means we command. It is an order from the Supreme or the High Court to the subordinate courts. Number 1, lower to subordinate courts, lower or subordinate courts. 2, tribunals. 3, private authorities. D, public authorities. Options are given. 1, A, 1 plus 2, B, 1 plus 2 plus 3, C, 1 plus 2 plus 4, D, 1 plus 2 plus 3 plus 4.
Option C, sir. 1, 2, 4.
1 to 4 because 3 private authorities you cannot ask for the manumus. Is it clear?
Yes, sir.
Appreciate.
Yes, sir.
12th question. The Constitution and various rights provided in the Constitution acts as a dash to our citizens. A, protector. B, custodian. C, caretaker. D, guardian.
A, protector.
Protector, sir. Option A.
If you say option A, protector, WRONG.
D is right answer, sir. D,
Sir,
custodian.
Guardian, sir.
Guardian is the right answer.
Yes, sir.
Even though guardian is a protector, even though guardian is a custodian, even though guardian is a caretaker, that's the reason we can say guardian and what's act. Is it clear?
Yes.
Yes, sir.
Very good. 13th question. Anyone can unmute and read?
The Constitution of India, as we all know, is a supreme law of the country, and every dash of our country has to dash by the Constitution. A option, person and abide. B option, people and follow. C option, citizen and abide. D option, citizen and follow.
C is right answer, sir. Citizen and abide.
Citizen and abide is the right answer. That is the appropriate answer. So now the 14th question. In the case of dash, there was a judicial review of subordinate legislation, and the court said that subordinate legislation does not carry the same degree of immunity that is provided for a statute passed by the competent legislature. And this was observed in the case of A, Binoy Vishwam versus Union of India. B, L. Chandrakumar versus Union of India. C, State of Tamil Nadu versus P. Krishnamurthy. D, Indian Express newspaper within parenthesis Bombay Private Limited and others versus Union of India and others. Which one is
D
the
is right answer. L. Chandrakumar versus Union of India.
wrong?
Voice is break, sir.
Sir, option D, Indian Express newspaper.
Option D is the right answer. Indian Express newspaper within parenthesis Bombay Private Limited and others versus Union of India and others. This is the right answer for the explanation of the 14th question. Now the 15th question. The parent document for drafting the Indian Constitution was the dash, and that document itself was very lengthy. A, Government of India Act of 1919. B, Government of India Act of 1935. C, Government of India Act of 1858. D, Indian Council Act of 1861.
Option B,
B,
sir.
Government of
Option
India.
B is the right answer.
India.
It is an easy question. I don't know. I want to cut it, but later I thought, no, better I will switch it. Okay, it's a Government of India Act of 1935. Okay, now I will switch over to the hard question. 16th question. Edwin Montague was the dash, Madhavi, mute. 16th question. Edwin Montague was the dash, and Lord Chelmsford was India's viceroy between the 1916 and 1921. I already missed something. Number A, Secretary and Viceroy. B, Secretary of State and Commissioner. And C, Viceroy and Secretary of State. D, Secretary of the State and Viceroy. What is the blanks. Who is the Secretary of State and who is the Viceroy? Yes.
Sir,
please
scroll
Edwin Montesquieu is the Secretary of State or a Viceroy?
Viceroy, sir.
is right answer, sir.
I removed, actually I forgot to remove that thing. Okay, now you tell me. Which answer is the appropriate? A, B, C, or D? Okay, I will pull down to the next page. Yes, now you tell me. Among the A, B, C, D, which is the right answer?
Yes, sir.
Wrong.
Right.
Should.
Yes, sir.
Sir, option D.
Option D. Secretary of State is the Montesquieu and the Viceroy is the Lord Chelmsford. 17th question. In 1918, Edwin Montagu, the Secretary of the State, and the Lord Chelmsford, the Viceroy, produced a scheme of constitutional reforms known as the Dash, reforms which led to the enactment of the Government of India Act of 1919. Number A, Edwin Chelmsford. B, Montagu Edwin Chelmsford. C, Montagu Chelmsford. D, Chelmsford Montagu.
Edwin Chelmsford. A.
Wrong.
He is right answer, sir. He is right answer.
Which one
He is
is?
right
Read the full answer.
Chelmsford, Montagu.
WRONG.
Montagu admin, Chelmsford.
Option
Vikram
A.
Kumar Vyas. Mute. మీ ఇంటికాడ మాటలన్నీ వినబడుతున్నాయి నాకు.
Option A is right answer, sir. Edwin Chelmsford.
Option C is the right answer. Montagu versus Chelmsford is the right answer. Option C is the right answer for the 17th question. Now, 18th question. Anyone can unmute and read?
The Government of India Act 1935 was an act
See, when one read it, another is stop it.
United Kingdom.
Not in chorus.
The original received dash.
Read once again.
Okay.
The Government of India Act 1935 was an act adopted from the Parliament of the United Kingdom. It originally received dash assent in August 1935. A option Imperial, B option Majestic, C option Queen, D option Royal.
Imperial.
Imperial, sir.
Imperial is right answer, sir.
Run.
Yes, sir. Yes, sir.
Option C, sir.
Sir,
Queen.
Royal, sir, correct. D answer. Option
D
D,
is the
Royal.
right answer. Royal assent. D is the correct answer. Royal assent. 19th question. I will read it. According to the petitioner, such a practice becomes rampant on the eye of the election. Such advertisement not only result in a gross wastage of the public funds, but constitute misuse of the governmental powers, besides the derogating the fundamental rights of the large section of the citizens as guaranteed by the Article 14 and 21 of the Constitution of India was observed in the case of A. Kumar City Residents versus Kumar Urban Development Private Limited. B. Navtej Singh Johar versus Union of India. C. Common Cause versus Union of India. D. L. Srinivas versus the State of AP.
He is right answer. The Navtej Singh Johar versus Union of India.
WRONG wrong.
Sir, option A, Kumar Cities Residents versus Kumar Urban Development Authority.
WRONG wrong.
He is right answer, sir.
Sir, S. Srinivas
And
versus
WRONG wrong.
Common cause.
He is right answer.
Common Cause of Union of India. Common Cause is one of the NGO and the central something another two NGOs they challenged this act. They say they are unnecessarily wasting the time and the grass will the public misuse is there, the governmental powers, and they challenged it and they won the case. Okay, 20th question. Match the following personalities from A and what they said in the part B. Part A, by Hassan Imam's view, by Bal Gangadhar Tilak, by Annie Besant, then by Surendranath Banerjee. I don't know whether you know who is the Surendranath Banerjee. He was the veteran Congress leader. Okay, part B, unworthy England to offer and India to accept. B, in favor of accepting the government proposal. C, declared the reforms to be disappointing and unsatisfactory and demand effective self-government instead. And the Montfort reforms were termed unworthy and disappointing, a sunless dawn. If the Montesquieu Chelmsford reforms on that one, they gave their own opinion. Options here I have given. A, 1C, 2D, 3A, 4B. B, 1A, 2C, 3D, 4B. And C, 1B, 2A, 3D, 4C. D, 1D, 2B, 3C, 4A. See the... Now shoot.
C is right answer, sir.
Yes?
1B, 2A, 3D, 4C.
Which one?
D.
The last D. DOG dog. Wrong.
D, sir.
B is right answer, sir. 1A, 2C, 3D.
The A is the right answer. 1C, 2D, 3A, 4B. By Hassan Imam's view, he declared the reforms to be disappointing and unsatisfactory and demand effective self-government instead. Bal Gangadhar Tilak say Montfort reforms were termed unworthy and disappointing, a sunless dawn. Annie Besant say unworthy England to offer and India to accept. And by Surendranath Banerjee in favor of accepting the government proposals. These are the views given for the reforms made by the Montesquieu and Chelmsford. 21st question. The Government of India Act was passed with the British Parliament in 1935 and came into effect in 1937. It was based on a report by the Joint Selection Committee led by A. Lord Black, B. Lord Spark, C. Lord Linlithgow, D. Lord Wilbright.
C is right answer, sir. Lord Linlithgow.
C is the right answer. Lord Linlithgow is the right answer. He is the joint committee, and there is C. Lord Linlithgow. 22nd question. Read.
This Berberry Union case was regarding the Parliament's power to transfer the territory of Berberry to dash. A option is Nepal, B option is China, C option is Pakistan, D option is Myanmar.
This Berberry Union case 1960 was regarding the Parliament's power to transfer the territory of the Berberry to dash. A. Nepal, B. China, C. Pakistan, D. Myanmar.
Pakistan, sir.
Answer is Pakistan. C is the right answer. And I told you the Berberry case law, it is said, preamble is not the part of the constitution. But later on it is reversed in the Keshananda Bharati case law. And that is called fundamental rights case law. 23rd question. Nirbhaya case 2014 within parentheses. Introduction of the Criminal Law Amendment Act 2013 and the definition of rape changed under the number 1. Protection of Children from Sexual Offence Act 2013. 2. Indian Evidence Act 1872. 3. Indian Penal Code 1860. 4. Code of Criminal Procedure 1973. Options here given. A. 1 plus 2. B. 1 plus 2 plus 3. C. 2 plus 3 plus 4. D. 1 plus 2 plus 3 plus 4. Right options you have to choose.
Sir, option C, sir. 2 plus 3
1
plus
plus
4.
3 plus 3, sir. 1 plus
Option C.
2 plus 4 is right answer.
Option?
C, sir.
Suppose if I agree, C is the right answer. Where is the wrong committed? Okay, I accept your answer is
Option B.
right.
Option C is the correct answer, sir.
I agreed. Show me the reason.
It was not related to the POSCO,
It's
sir.
for the age under
It
16
was not
years.
related to
No,
POSCO.
no. See, Protection of Children from Sexual Offences Act 2012. I wrote how much? What I wrote?
2030.
13.
You have to give the reason. No doubt you shoot it, but the reason you are not given me. I just changed the year to make you confused. And I know that everybody makes 1 plus 2 plus 3 plus 4 because the definition of the rape is changed in all the 4 acts. Am I right?
Yes, sir.
Sir.
Yeah, you are shooting, but I want the reason. That's a very important factor. Okay, no doubt. You will pass 40 marks getting if you are regular to my class. I will Surpanakana and Mukku koskunnedi.
Surpanaka, sir.
నేను నా ముక్కు కోసుకుంటాను if you attend my class and you fail. Okay, 24th question. Match the title of the case like part A and held in part B. Part A, Vishaka versus State of Rajasthan. 2, Vamana Rao case. 3, Menaka Gandhi case. 4, Lily Thomas versus Union of India case. And what is held in the part B? The second marriage of the Hindu man without the divorcing his first wife. B, the right to go abroad is a part of the right to personal liberty under the Article 21. C, the basic structure doctrine. D, sexual harassment at the workplace. I am sure that is easy, but I would like to see how many people can make it out. Options: A, 1C, 2A, 3B, 4D. B, 1A, 2D, 3B, 4C. C, 1D, 2C, 3B, 4A. D, 1B, 2D, 3C, 4A. Okay, here I am showing the options. I am sure that you can make it out. It's not that much tough.
So, Menaka Gandhi case and
Scroll up,
passport
sir.
case.
Scroll
That
up,
should be
sir.
B.
See, Menaka Gandhi case, passport case means right to liberty to impound the passport means your personal liberty is curtailed. Means Article 21.
Yes,
Sir,
sir.
Vishaka versus State of
Vishaka
Rajasthan.
means, you know the Vishaka case law. And the poor lady, Bangladesh lady, and she was brought over here, and the railway Nilayam people of the Calcutta, they gang raped her.
Sexual harassment.
No, not the railway Nilayam. No, that is different. Rajasthan, this is child marriages, sexual harassment at the workplace.
Sir, scroll up, sir.
Yeah, Lily Thomas, when your wife is alive, you should not supposed to marry. Or Vaman Rao case, Fundamental Right case. The right answer is
D is right answer, sir.
A is right answer, sir.
C is right answer. Here I am giving C. Vishaka, sexual harassment at workplace. Vaman Rao case, basic structure doctrine. Menaka Gandhi case, right to go abroad, Article 21. Lily Thomas, you are not supposed to marry when your wife is alive. It leads to the bigamy. What is the IPC article?
494.
Is it 494 or 496?
494 only.
Okay. Yes, the 25th question. In the case dash, a quo warrant cannot be issued for dismissing the chief minister of a state on the reason of non-performance of his constitutional duty. A, K.R. Ramaswamy alias Traffic versus the chief secretary. B, N. Abdul Jabbar versus Sunnakala Shetty. C, Y.S. Rajshekar Reddy versus Nara Chandrababu Naidu. D, C, Kuppuswamy versus Chief Election Commissioner. It is an easy question. It's not that much tough.
D answer is right. D.
It is
D, sir.
Y.S. Rajashekar Reddy versus Nara Chandrababu Naidu case law.
Oh.
26th question. The office of the chief minister is created by dash. So member of assembly is not a purpose of office. Raising the question on the election of chief minister in this writ is not proper from it must be raised through that and dash. A. There are two dashes are there. A. Parliament and election petition. B. Legislative Assembly and High Court. C. Constitution and Supreme Court. D. Constitution and election petition.
C, sir.
Constitution and election petition.
Constitution, you cannot challenge the chief minister for the purpose of his office is concerned. And if it is there, because the constitutional mandate is there, and you cannot make it the courts, you can file in the election commissioner, you have to file the case first. If you are dissatisfied by that one, then you can go to the apex court. Is it clear? So the right answer is D. Constitution and election petition. 27th question. A writ petition was filed by the Sheila Barse. It's a famous case law. Sheila Barse. A. Dash. A freedom fighter. B. Journalist. C. Photographer. D. Human rights activist.
Sir, option C, photographer.
Wrong.
Journalist, sir. Journalist, option B.
She is a journalist. Sheila Barse is a journalist and she filed a case under the PIL. Can you tell me what is the case? It's an easy question, but I don't want to ask. That's why I only ask that whether he's a journalist or photographer or human rights activist. Okay, now let us see. Please remember the cases, some like Vishaka case, very important, and common cause course. Now just Sidhu case law, and what is that? Delhi case law, transgender. I will tell you the name of the case. National Legal Service Authority versus Union of India. Are you following me?
Yes, sir.
Joseph Shine case law. Okay, now 29th question. How many times you will all get the cases in my earlier my video? You get all the cases there. How many times Constitution of
Right
India?
answer, sir.
Yes.
Is right answer 105.
See, let me read. Let me finish the option D. Okay, how many times Constitution of India amended and now are updated? A 103, B 104, C 105, D 106. Shoot.
105.
Shooted.
Option C.
105, sir.
Now you tell me, what is that amendment? What it says about the amendment? Whether the reservation should be continued for the minorities or economically backward people. What is that? Please, that also very important factor.
Economically backward.
EBC reservation.
Economically backward.
Yes, that is the point. That is the point. As of October 2021, there has been a 105 amendments of the Constitution of India since it was first enacted in 1950. 30th question. Which is an amendment inter alia curtailed the powers of the Honorable Supreme Court of India. It was totally a draconian amendment aimed to establish the supremacy of the executive. Options: 40th Amendment, 41st Amendment, 42nd Amendment, 44th Amendment.
Option C, sir. 42nd Amendment, sir.
Why you are taking so much time when you say draconian? Number one. Number two, a frustrated amendment. Number three, worst amendment in the period of Indira Gandhi, which is made over there. And among all the amendment, it is a draconian amendment.
So many amendments, 42 amendments, sir.
Yeah, many, of course. She has made many things. See, monopoly is a very dangerous thing. Success is very dangerous. Success is like a pinpoint. No one can stand over there for a longer time. Okay, now it is gone. Okay, now. Yes. Now let us go to the 31st question. Which amendment is the least important? A. Third Amendment. B. 13th Amendment. C. 15th Amendment. D. 24th Amendment.
Third
Option D,
amendment.
13th amendment, sir.
Repeat.
Option A, sir. Third amendment.
Option
Option
A.
A.
Third Amendment is the least important amendment. I am not asking what is that amendment it is. Okay. The Third Amendment seems to have, yeah, no direct constitutional relevance at the present. Indeed, not only it is the least litigated amendment in the Bill of the Rights, but the Supreme Court has never decided a case on the basis of it. That is about the Bill of Rights, fundamental rights, something like that. Okay, 32nd question. The Dash Amendment to the Constitution enacted in 1978 removed the right to property from the list of the fundamental rights and replaced it with a legal right under Dash. A. 43rd Amendment and Article 300 capital A. B. 44th and Article 300. C. 45th Amendment, Article 300 capital A. D. 44th Amendment, Article 300 capital A.
D is
Option
right
B,
answer,
sir.
sir. 44th amendment.
He is right
Article
answer, sir.
300A.
46.
Yes, I appreciate. You are good in the amendments. It is the 44th Amendment. They removed from the fundamental rights the right to property and put it in the Article 300 capital A. It is like a constitutional remedy. Is it constitutional remedy or a general right? Something like that.
Sir, constitutional remedy.
The 44th Amendment to the Constitution enacted in 1978 removed the right to property from the list of the fundamental rights and replaced it with a legal right. They say legal right under the Article 300 capital A. They may ask also, they removed from the fundamental right and kept dash right, statutory right, legal remedy right, or something like that also. Supplementary question. Is it clear?
Yes, sir.
Yes, sir.
Okay, 33rd. Yes, anyone can unmute and read the 33 question. If one
Which is the
started
most
reading,
powerful articles in Indian
Yeah.
Constitution?
read.
Which is the most powerful article in India Constitution? A. Article 19, B option, Article 21, C option, Article 32,
Article 21
D
is
option, Article
powerful, sir.
56.
Let the
Option C, sir.
person will
Option
read
C,
first.
32.
When he come to the end of the option D, then you can shoot. Shoot.
Option C,
Option
sir.
D.
D,
Article
Article
32.
356, sir.
D.
If you say Article 32, that is the heart and soul of the Constitution. But if you say Article 356, that is a powerful article. What is the powerful article 356? Who has given the power to whom? Husband has given the power to the wife, or wife has given the power to the husband.
President is powerful.
356. This is the article in the Indian Constitution, deals with the imposition of the president's rule. The president is the supreme authority in the Indian political landscape who has the power to make many decisions, man to woman, woman to man. 34th question. Which article is most fundamental? A. Article 14, B. Article 19, C. Article 21, D. Article 24.
Article
D is
option
right
A.
answer, sir. Article 19.
Article 14.
B is right answer,
Right
sir.
answer,
Article
sir.
19.
21.
21 is the right answer. If
D is
ever
right
used.
answer, sir.
21 is the right answer. Is a fundamental right and is included in the Part 3 of the Indian Constitution. This right is available to all citizens as well as the non-citizens alike. According to the Justice Bhagwati, Article 21 embodies a constitutional value of the supreme importance in the democratic society. 35th question. Who has the shortest constitution in the world? A. US Constitution, B. Malaysia, C. Indonesia, D. Seychelles.
Option C, sir, Indonesia.
Indonesia is having the smallest constitution. And here I have given the Indonesia Constitution of 1945 is the shortest constitution in the world. It is much shorter than the US Constitution, which is usually claimed by some American scholars are the shortest. The US Constitution contains the 4608 words compared to the Indonesian Constitution 1945, which contains only 1393 words. Supplementary question. Which country constitution is the oldest constitution? Yes. The oldest constitution of which country? Of course.
America.
No, America is there, but implementation. But the oldest one is the Constitution of San Marino. The Constitution of San Marino might be the world's oldest active written constitution, since some of its core documents have been in operation since 16,000, while the Constitution of the United States is the oldest active codified constitution. But the oldest, when you say San Marino, but the implementation is concerned, we can say US Constitution. 36th question. In the case of State Bank of India versus T.J. Paul, an employee working in the Bank of Cochin was served with charge sheet, but the bank was amalgamated with the State Bank of India after a certain time, and it was held that a person cannot be convicted with the rules of the State Bank, and only the rules of Bank of Cochin is applicable to him based on which article? Article 20, Article 20, Subarticle 1, Article 20, Subarticle 2, Article 20, Subarticle 3.
D is right answer, sir. Article 20. Yes, sir.
Read full answer.
D is right answer, sir. Article 20, subsection 3.
Why you are swallowing the other word? Article 20 and you are swallowing. You know what is Article 20? 20 and 1 and 20 and 2 and 20 and 3. 20 and 3 is self-incrimination.
21 is right to liberty, sir. 21.
But which is the right answer here for this case law?
D is right answer, sir.
Which one?
B is right answer, sir.
See, you are not
Article
supposed to
20,
say that way.
subsection 3.
B, Article 20, Subarticle 3. Is it the right answer?
Yes, sir.
Wrong. The right answer is Article 20, Subarticle 1 is the right answer. The reason is,
D is right answer.
when you committed a wrong on that day, what law is prevailing, that will be holds good. When you compare the Article 20 sub Article 2, a man cannot be jeopardy, means punished for the same offense twice. Article 20 sub Article 3 is concerned, no one can be a witness for his own case, self-incrimination. 37th question. In the case of Hussain Khatun versus Hussain Ara Khatun versus State of Bihar, the right to speedy trial also come under the dash of Article 21. A. Real. B. Domain. C. Sphere. D. Ambit.
Domain, sir.
Wrong.
Ambit.
Ambit is the right answer. 39th question. Article 21, capital A, guarantees the right to free and compulsory education to the children aged 6 to 14 years. This provision was added in the year 2002 by the dash. Which amendment? 83rd Amendment, B. 84th Amendment, C. 85th Amendment, D. 86th Amendment.
Option A, sir. 83rd Amendment, sir.
WRONG, wrong.
86th Amendment, sir.
Sir, 84th Amendment.
If you say 84th Amendment, WRONG, wrong. The right answer just before somebody said, it is a D. 86th Amendment, where if the free education is given children aged 6 to 14. 40th question. In the case of state of Gujarat and other versus Honorable Court of Gujarat, it was held that the Article 23 must be always provided with a dash interpretation. A. Beneficial interpretation. B. Strict interpretation. C. Linear interpretation. D. Purposive interpretation.
C is right answer, sir. Linear.
Strict interpretation, sir.
If you say strict interpretation, WRONG wrong. If you say linear interpretation, it is a WRONG wrong.
Sir, option A, beneficial interpretation.
If you say beneficial interpretation, WRONG.
D is right answer, the purposive.
Purposive interpretation is the right answer. So, this I kind, some of them are tough, some of them I give the lineal, so that at least you could brush yourself. And tomorrow also that I am going to deal the same, because Constitution having the more marks. Are you following me?
Yes, sir.
Yes, here you could see it, syllabus for All India Bar Examination, 17th cohort 2023. There's a number of questions is 10 marks are there, and today is 7/1/2023. Tomorrow is a holiday. You can enjoy the holiday with your parents and so on and so forth. And again we will meet on 9/1/2023, and already I posted the timings of different days. Different timings are there and you have to follow it. Please, today I could find that many are newcomers are there. They don't know how to mute and unmute it. When you want to speak at the time, you can unmute it. When you don't want to speak at the time, you can mute it. Otherwise I could hear the voice which are dialogue between you, which is going on in your house. Not only me, everybody will hear the same. Am I right?
Yes, sir.
So now at any time it will stop, and I could see that I requested some of them to take the screenshot. I don't know whether you have taken the screenshot or not. I appreciate there are 29 today, but whether somebody has disappeared or not, I don't
31,
know.
sir. No, sir. 31 participants.
Yes. Idhar ji, isme aa raha hai, no? Yes. So now it is Shanaz, take the phone. Yes, there are 29 are there, and you could make it out. So tomorrow that we will meet it. Of course, after tomorrow we will meet the Constitution, and tomorrow is after tomorrow is the Monday. The same timings of the India timings 9:10 to 10 o'clock. So with this, I would like to say goodbye and have a good day. Then over.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
We live in a world full